Hey guys, my name is Toby Mathis, and today we're going to go over the 8 essential differences between a living trust and a will. So I'm a partner at Anderson Business Advisors. We've been doing this for 25 years, worked with thousands of folks putting in proper legacy planning and estate planning, and we're always getting that same question, what's better, a will or a living trust? And I can just tell you from our experience in having done this and worked with thousands of people and actually shepherded so many different estates, especially in the recent years with COVID, where you're having people that have passed away and you're seeing this stuff in practice day in and day out. And I can tell you what works and what doesn't. You can kind of ignore the folks that don't do this for a living, because there's what actually works in practice and there's what is a theory. So I'm going to give you what is working in practice. And let's just start with number 1, and that is the probate process. There's 3 options you have. Let's see if I can make that show up. So you have 3 options when you're dealing with estate planning. 2 of them are going to go through something called a probate process. And what a probate process is if an asset, because like let's say that I own something during my life and my life ends, where does that asset go? Sometimes there's a state statute, like maybe I have joint ownership, maybe there's a paid on death clause. So there's these little niches that allow an asset to transfer, or I have joint tenants with right of survivorship. So maybe it's 2 spouses and one spouse passes and it goes to the other. That avoids the probate process, where you don't need to go to court to transfer an asset. So all probate is taking an asset that was in your name and it's still in your name when you pass away. So you need to get a court order to transfer it. So there's 3 ways that an estate can get handled, 2 of which require probate. And people are going to say, oh, you should avoid probate. It's the worst. It takes a lot of money and it's really time consuming. For the most part, they're right. It's not a good thing. Like usually court, whenever I think of court, it's your worst behavior on your worst day, and that's what you're pushing on to your heirs. They're going to be dealing with lawyers. They're going to be scared. They're going to be uncomfortable. They're going to be going in and they might have to advocate for themselves, which causes frustration and fear of missing out or loss, and that somebody's going to take advantage of them. There's expense and all those things. So for the most part, I'm not a big fan of probate. I'm going to say avoid it if you can. And like I said, there's 3 options. I'll go over them. 2 of them land you in probate. So only 1 avoids it. And that's what we're going to be focusing on. And that one thing that avoids it is that living trust. The other 2 are, I do nothing. It's called dying intestate, and you go under state law. Number 2, or the other one is a will. So 1, 2, 3. 1 is intestate. I did nothing. 2 is I had a will, and I'm going to go get a court order to transfer the asset. Number 3 is I put the asset into a trust before I passed away. So let me just kind of go through this so that you guys actually have it. So there's 3 ways. I'm just going to say can go. And I'm just going to put that. A probate equals a will. Avoiding probate is the living trust. So there's 3 ways we can go. Intestate, didn't do anything. I'm going to go under the state statute that I'm in, like Prince, if you remember that. You know, it's like he didn't have anything. So Minnesota law, they're fighting for years. I think it's still going on, gosh knows. But it takes a long period of time as a result. But you're going under state law, or you do a will which says, here's who gets my stuff, but you're limited really on that transfer. Here's who gets my stuff. You can't be much more creative. There's a lot of issues that we're going to go over that you may want to address. And we want to make sure that we have a document that's actually comprehensive enough to address those things. And then you have a will where I don't own the asset anymore. Like I put my house into a living trust. I don't own it. So if I die, doesn't really matter. I just have in a trust, you're going to see a lot of 3s here, right? There's 3 parties. There's the grantor who puts the property into the trust. There's a trustee who manages that property, and there's beneficiaries. That's who gets the ultimate beneficiary of that property. So you have somebody give it, you have the trustee who manages it for the benefit of the beneficiaries. If it's a living trust, it means I'm all 3. I can change them whenever I want. It's revocable, but I'm putting the asset out of my name, because when I die, I can't take it with me, right? So it's going to stay here. I need to be careful about who is going to get that asset, under what conditions, under what terms. And a living trust allows me to be very, very versatile and very specific in those issues. So when I pass away, the grantor was me. The beneficiaries during my lifetime is me, and then I have successors. And I have trustee, which is me, and then I have successors. So when I pass away, the only thing we have to look at, it's private. You don't have to get a court order to do any of this. It says, oh, Toby's gone, and his, let's say you're not married. We'll make that easy, or you're the surviving spouse. You pass away. Oh, who's going to be the trustee? Maybe it's another family member. Maybe it's a bank. Maybe it's a trust company. Maybe it's a trusted advisor. Maybe it's an institution, right? But you have somebody designated to take control of that asset and fulfill your wishes, which is what you put into the living trust. We'll get into some of those provisions here in a little bit. But that's the big difference, is that a will equals probate. A living trust avoids probate. A will equals a straight transfer, whereas a living trust gives us other options as to how we transfer. We can be far more creative. We can create a legacy plan. You cannot create a legacy plan with a will, but with a living trust, we can actually create a legacy plan. There's a whole bunch of other issues that we're going to get into, but at its core, this is what most people know. They're looking at it going, all right, what's the difference between these two things? One, hey, I have to go through this probate process. One, I don't. Number two, and I'm just going to say this, real straightforward. Wills are not fast. Wills are not fast. In other words, you can create them quickly, but in practice, it takes many, many months to actually use a will when you're going through the probate process. Now, let me break this down for you. Since we're going to go through a court process, the will is going to say who gets what. Then there's statutes that say, here's the time frames that you have to give notice to everybody from creditors to the other beneficiaries. That's where people start coming in and saying, hey, we need an accounting of the full estate. We need to, and there's going to be time frames. On average, it's 18 months. On a small estate, if you're under, let's say, 50,000, in many states you have a expedited probating process that might be 90 days to 6 months. But whatever the case, it's not fast. When you use a living trust, it's automatic. It's done. I'm gone. The asset's already in the trust. Assuming you funded it, right? Some of you guys out there have the living trust, you just never put anything in it. In which case, you may still have a probate process, but we're going to go over that. It's going to be called a pour-over will, and it's only one beneficiary. At least you don't have to give the whole family notice. Like you're not going to have these crazy claims and all sorts of craziness going on. But the big issue here is wills are not a fast process. You just got to understand that when you go in. So if I do a simple will and I have a bunch of I would say any assets that's more than one piece of real estate, over $100,000, you're probably going through a much more thorough process than if you had a really low income estate. Like most states will treat the smaller estate a little bit differently. Now, just to give you an idea of the cost too, because when you hear not fast, there's lawyers involved in this process. You're going to have professionals going in doing valuations and things like that in this process. The more complex the estate, the bigger the estate, the more it is. So I'm just going to give you the rough numbers. ARP did a study, and they came out with a 20% marker on smaller estates, which means the probate process, this thing, was taking between 12 and 18 months, and it cost about 20% of the estate. And I know some of you attorneys are out there like, no, that's not true. Well, actually, ARP did come out with that, and that was exactly what they said. For smaller estates, overall, there's the big association of estate planning attorneys, and they all say somewhere between 3 and 7% on the average estate. But the average estate isn't $50,000 or $100,000. Like you're getting into where, hey, I have a few $1 million. 7%'s a big chunk, right? 3% of that is a big chunk. You're talking, what is that, 60 grand to 200,000 in probate costs. And it can be, for the most part, avoided. And that's why guys like me are out there all the time saying, hey, there's 3 choices. Only one of them avoids that legal process where if I never enter a courtroom ever again in my lifetime, it'll be too soon. I'm fine having clients never go to court, ever. Court usually isn't where good things happen, and it's usually not where you go in there and I'm happy. You're putting yourself under discretionary authority of somebody who can decide what to do with your stuff, and I would assume avoid that. And so it makes it really simple for a guy like me, because I look and I say for my client, I need to avoid this one thing, and there's only one thing that avoids that one thing, so I'm going to do it, right? It makes my life pretty easy. So wills are not fast. Number 3, wills only work on death. In other words, you're not using them while you're alive. When you do a will, you don't know whether it's going to be screwed up or not until you're gone. And it's going into court process, and now it's being contested. And you always hear these stories of a will that's not enforceable, provisions that's not enforceable. There's plenty of them out there where somebody intends to, like, there's actually some prominent folks. I think Princess Diana was one that's where she's trying to benefit some of her staff, and unenforceable provisions, we're not going to give them anything. Right? You have to follow certain criteria when you're using a will, and even to change it when you do what's called a codicil, you're actually having to meet the same requirements of the will. Everything from, does it need to be witnessed? How many, are there holographic wills in my state? Some states yes, some states no. That means that you verbally speak out what you want. Or can I write one out, or do I have to follow formalities? And something that you think, hey, I wrote something out, I signed it, but it's not enforceable, so I'm going to go under state law, and a judge gives your stuff to somebody that you never intended. You had written it down, but it didn't meet the requirements. You didn't know until you were gone. Otherwise, you would have fixed it, right? Well, with a living trust, it's actually in place during your lifetime. You transfer the assets during your lifetime, and so it's actually in place. And this is a big one, and I'll go over it a little bit later too. But if I'm incapacitated, I already have the trust in place, right? I already have a successor trustee. If I can't handle my own financial matters, for example, because of, maybe I'm very, very sick. We saw this in COVID. People go, maybe you're in the hospital for 3 or 4 months, or I have Alzheimer's, or fill in the blank. If I'm not able to handle my estate, I already have somebody that's named inside that living trust. And there's another document that we use as well that goes like this, that's always included with an estate plan. But what we know for sure is a will does not. So a will only works upon death, whereas a living trust is during your lifetimes. Now, it's a lifetime document that you can change. So if I am sitting here right now and I have minor children, and I'm thinking of, hey, how do I want to treat my estate with regards to those minor children? And 20 years later, these children are grown up and they're very responsible or whatever. Maybe 1 or 2 have become very, very successful, and you're saying, hey, I want to change things up. Maybe I'm focusing out on my grandkids now. Or, hey, I'm not too worried about certain things. Or I want to create a dynasty. I want to create a legacy plan that's going to benefit not just my kids, but my kids' kids, or my kids' kids, kids' kids, kids' kids' kids, right? I want to create something that's this long term. Maybe I'm funding education for my family. Maybe I'm making sure that nobody's homeless. Whatever the case, I can do that inside of a trust. I cannot do that with a will. So I'm going to go over what are next is I only have one distribution option when I'm a will, which is to distribute it. Who gets it, Your Honor? And the honor signs it, right? With a trust, there are really 4 different ways you can distribute. I'm just going to put them into kind of categories. Number 1 is I could do an outright distribution. I could say, hey, if something happens to me, it goes to my kids, right? Or if something happens to me to mom and dad, it goes to my kids. That's just called an outright distribution. Hey, just distribute it. Trustee, distribute automatically. I don't have to go to court. I don't need a court order. I don't need to go through that whole process. It could take 2 days. It could take 2 weeks, whatever. I'm going to transfer everything. Just distribute it all to my kids. Number 2 is I could say, hey, I'm worried about my kids at certain ages. So maybe give them 25% when they are 25 years old. They still get what we call health HEMS, which is health education, maintenance, and support. Maybe we have my trust holds all these assets, so I pass away, and the trust is holding these assets for the benefit of my beneficiaries. Maybe it's my kids, maybe it's organizations, maybe it's people I know, but I have assets being held for beneficiaries. And that's still going on. But then my beneficiary has the right to go up and say, distribute 25% of those assets at a certain age. So maybe I say, hey, 25% at 25 years of old, 50% at 30, and the rest at 35. Whatever, you can fill in your blanks. because you're concerned about ages. Hey, I don't want to dump a large amount of assets onto somebody who's not prepared to handle it. So I don't want to give somebody who's young, maybe they're 18, and I give them $1 million and they go this way on their life, when if I hadn't done that, they would have gone the other route and maybe been a more responsible member of society and benefited themselves. I've seen this actually, guys. I've actually physically watched somebody drop out of school, stop what they were doing, and spend down an estate for 3 years, and then be in a world of hurt because they ran out of the money, and they're like, crap, now what do I do? Well, they had stopped what they were doing. They went down a different path. They basically killed 3 years partying and doing that stuff. We've seen that. Like, you probably all know somebody who's been in that situation where they had a windfall, they changed their life, and as a result, it hurt them. We can just look at lottery studies, and the prevalence, I think it's after 5 years, the rate of bankruptcies for lottery winners is higher than the rest of the public. This doesn't mean that they're all going to go bankrupt, but it just means that when you look at things as to what normal, like what would have happened, what would have been the average had they not won the lottery, they would have been better off in many of those situations. So when somebody gets a windfall, the chances of it sticking around is oftentimes, like there is another study out there that shows the chances of something making it 2 generations when you give it to your kids, for example, the chances of it getting to your grandkids is less than 20%. It's a really small, like it just goes, and that's because we're dumping something onto it. So maybe we don't want to just dump it onto somebody. Maybe we want to put, hey, here's some age limits. It might be in your book, you might say, hey, maybe they get 25% at 30 years old, 25% at 40, 25% at 50, and the rest at 60. Because they're probably pretty responsible that time. We haven't had something that just completely changed it. So there's that option too. The other option is intervals, meaning like, hey, I give it over, hey, give 10% every 5 years for a certain period of time. And again, all while this is going on, they still have access to the money if they need it for health issues, if they're going to go to school, if they have medical stuff, so health, education, maintenance. Hey, if I need to be, you're not going to be homeless, you have money that will help cover and support to make sure that you have some money coming in so that, again, you're not a burden on society, but hey, we'll make sure that you're not following below that line to where you end up in financial straits. Your trustee will still fund them a certain amount to make sure that they're maintaining a lifestyle, but it doesn't need to be exorbitant. It can just be a reasonable amount, like, hey, give me money for a Lamborghini. No. But I need a car. Okay, there's Hyundais and Kias out there, right? Like you can get, or a Toyota, like here. Like it doesn't need to be the craziness up here. We can actually be pretty reasonable with an estate, especially if you pick a good trustee, somebody who's going to shepherd that money. Which, by the way, if I've been going to give you any feedback on that one, it's probably best if you don't have somebody in your family that you trust, or you don't have an advisor that you trust, or a firm, is to pick like a bank. Go find a wealth department of a bank, because they have to follow pretty rigid standards, and they deal with this stuff all day long because they have trust departments that are having to work with this type, so they're used to it. So they're used to saying no all the time. They're used to pushing back and saying, here's about the right limit, because that's what they do for a living. You could do that and then save yourself a lot of pain and suffering if you're like, never make the beneficiaries the trustees, because they'll just be like, oh, should I have this? Yes, I'll just take that. But anyway, so we've covered 3 of the ways you could distribute an estate. You can have outright, you could have at ages, and you could have at intervals. And then the 4th one is to create what I call a dynasty trust, which is, hey, we are creating something that's going to go on for many, many years. Like where I'm standing right now in Nevada, we use a 365-year statute. That's where we're usually drafting. So we can create a trust that at its inception is going to be this 365-year. Once it kicks in, it's 365 years. When you pass away, it becomes irrevocable. We have this long term for this trust, so that so that you can handle multiple generations. 365 years is about 12 generations. So you're really creating a legacy for your family when you do that, and you're not giving any guaranteed distribution. So what that means is, and you can get creative with this stuff. You might say, hey, what really matters to me is that you do mission work, or that you go to school and get a 4-year degree, or what really matters to me is that you travel the world, so once a year I'll pay for you to go to another country, that type of thing. So I could put that in there with health, education, maintenance, and support. Or you can get rid of all the other things and just say, hey, I just want to be an educational trust. We're going to pay for school for any of my descendants. Period. Full stop. As long as it's, your trustee, you can put vetting requirements on the school. Hey, as long as it's accredited university in a 4-year degree, we'll pay for it. Or you could even be more specific. You could say 4-year degree in math or science. Like you could be as narrow as you want, as broad as you want, but you have the ability to create, and my personal view is this is the way to do it, is to create a legacy for your family and say, hey, if I'm going to work and I'm going to build up assets, especially if you have business assets, especially if you have like real estate where you don't want them sold, you don't want them liquidated when you die, you want them to continue to create income for future generations. I'm a big fan of something called infinity investing, where I'm creating perpetual income streams. I want to be able to give that income stream. I don't want them to sell off my estate. I want my estate to stay intact and continue to generate income for future generations, right? I don't need it to be liquidated and sold off. That's a lot of estates do that, and that's why we actually do some sort of estate planning. But you could be creative, and so we have 4 options. So I'm just going to say living trusts equal all 4 options for distribution. See if that's on there. So you have all 4 options for distributions. Hey, I can give it outright, I can give it at ages, I can do it at intervals, or I could just put in there a restriction that says, hey, we're creating a legacy trust and it's going to carry on for multiple generations. So that's a big one. Wills only have 1, right? So it becomes pretty clear. So if you have a sizable estate, it's a no-brainer. You're going to do a living trust because you're not just going to distribute assets because you're not doing anybody a favor. Now I'm going to go to a slightly different topic real quick. I want to hit on something that is really, really important since we're talking about larger estates. When you are doing a will, when you have a will, one thing that a lot of people don't realize is that any state that I own assets in, any states that I own them individually, that's a separate probate. So when I have a will, and I'm not putting it up here as on our list, I'm just going to say this as an aside. Anything that I just said, anything about probating, multiply it by the number of states where you own real estate. And that is assuming you didn't do an entity structure. If we just do land trusts, LLCs, then you're good, because now that we've converted that into personal property, we don't have to worry. But if you own, or somebody that owns like a house in Nevada and a house in Florida, and it's in their name, they're probating in both places. They're going to have 2 court proceedings. I've seen that too many times. I just want to say it as an aside. Please don't allow somebody to do that. Just talk to them, say, hey, at least do an entity structure and avoid that probate that way. Better off is to do an entity structure with the living trust so you never have to go to court in the first place. All right, number 5. This is a big one. And I'm just going to, I'll put it up here in a second, but I'm just going to say it. There's this weird stuff that happens to beneficiaries. I'm just going to say it like this. There's things like they might have special needs. So I have a beneficiary that's autistic or has been getting assistance from the state, and I give them assets. The state could take that. So you need to have special needs provisions. Every document I ever drafted has special needs provisions for this very reason. Special needs just means, hey, I'm not going to distribute money automatically to somebody if it's going to cost them a benefit. So if the state is supporting somebody and all of a sudden I dump a bunch of assets on them, that may cause the state to cut their support, and you may do them more harm than good. If I leave assets, there's actually a case on this where an individual, it was a great couple, and they left their money not to their kids, but to their grandchild who was autistic. And the state had been supporting that individual and providing them assistance throughout the parent's life. So they were like, okay, the parents seem to be pretty good, but we really worry about our grandson. So they left a nice sizable inheritance to the grandson, and the state of Pennsylvania took it. They went in and made a claim against it saying, hey, we've been providing all this assistance. We would like to be reimbursed, please, now that this individual has all these assets. And so they went after the grandson to get reimbursed for all the things that they'd been paying on that grandson's behalf. Yes, stuff like that actually happens. And so you put in there a provision that says, hey, trustee, don't give the beneficiary these assets if it will cause them to lose a benefit. That's it. The only time you're giving them a distribution is for very special needs, right? Designated things that will not cost them to lose a benefit. And I've been a court-appointed guardian before. I know that there's certain items that work. Like if somebody has assets, they're going to have to spend them down or they're going to have to blow through them in many state programs and federal programs. What we don't want is to have them have that asset be part of that calculation. And by using a special needs provision, it's not. Number two is divorce. If somebody's going through a divorce, you pass away, and it's one of your kids or it's a beneficiary, and you dump a bunch of assets into it. These are generally considered separate property, but they still are considered when the courts are looking at a fair and equitable distribution of marital assets. So, hey, I'm not supposed to think about my separate property, but the court can still do what's fair, and they think about separate property. Or I leave assets to somebody and they're in a marriage that maybe is rocky, and that money gets put into the joint account. You know, hey, this money comes in. Hey, you know, maybe one spouse is Mr. Spender or Mrs. Spender, and they start running through your estate, and then a divorce ends up happening, and these assets are now part of that because they commingled it with other assets, and the next thing you know, your estate's going to the person who's divorcing your beneficiary. You may not like that. So we do like to have provisions put in there like, here's a beneficiary, this is theirs, and you can even put in provisions that say, hey, it has to go into a separate trust or has to go into a separate account to make sure it is separate property. Yes, you can actually put things like that in there. You can even put that in there for like a surviving spouse. Hey, something happens to me and we create a trust that is my asset, so I make sure it goes to my kids so I don't unintentionally disinherit them. Like this stuff happens, guys. It actually happened in my family. So a lot of times people just leave everything to their spouse. And so think of it like this. Right now I'm married. I pass away. Everything goes to my spouse. She remarries. She predeceases her spouse. Everything goes to him. I just disinherited my family. Everything's going to be with that, the new husband. You can go down his family line. So the way you control that is you say, hey, if something happens to me, it goes into trust for the benefit of my spouse. But if she remarries or he remarries, they have to sign a prenup that this is not part of that. This is not their asset. So it's like this. Hey, there's two people. They have an estate. And we're cutting it in half when somebody passes away. That's still there for the benefit of the survivor if they need it. But we already know who the beneficiaries are of that half. It's going to go to the kids or whoever the beneficiaries were when that spouse who's now passed away, when they were alive, it goes down their line and doesn't just automatically go to the survivor. Because again, that survivor, I'll give you a real life. This is going to trip you out. So this is real life. Gentleman, wife, married, happy marriage, very conservative family, three kids. I got brought in by a family friend. The wife got cancer. She passed away. Husband, his best friend wasn't his best friend, but it was his lover. And decided and came out to the kids and said, hey, this is going to be my life partner. And the kids were upset. Not, we could always say conservative reasons. They were a Christian family, so that it upset them because of their faith. But it upset them because that was the guy that was always around their family. That was like your dad was cheating on mom, and now I'm supposed to accept this, and I'm upset about it. And so dad said, I'm disinheriting the kids and leaving it all to the guy. What would mom say about that? Mom didn't know. Mom's passed away. Mom has no control. But everything's going to go, in theory, to this gentleman that was having an affair with her husband. So regardless of how you look at the situation, I could say it's pretty messed up, but I could say that pretty clearly if we could go talk to mom, she'd probably not be too pleased about it. She'd probably be like, what? right? And, oh yeah, like, I want my stuff to go to my kids. Well, because she did not put a plan in place, dad can disinherit the kids if they don't agree with him, or if they get into a fight. It ends up being that the money can be used as a weapon. You want to avoid that. You're making sure that type of provision is in your trust. So we want to make sure that we're covering things like special needs, divorce. Here's another one. It's called a credit shelter provision. Again, I put it in all my documents, and our firm puts it in all of our documents. What it is if you have a beneficiary who's going through a bankruptcy or who has creditors, and they're having trouble paying their bills or whatnot, and there's somebody coming after their assets, if we just give them the money, it's going to be part of those claims. So we instruct the trustee not to distribute money if it's going to go to a third party, not to distribute money to the third party. These are called credit shelter provisions, and it shelters the money. It shelters the money because a beneficiary is in peril. What it does is it keeps your money from going to some creditor because your beneficiary made a bad decision. You may not even know. Like, hey, I leave it to my son and he's going through a bankruptcy. I don't even know he's going through a bankruptcy. I pass away, everything goes to him, and all of a sudden it's part of the estate and it's going to his creditors instead. That's not my intent, right? My intent was my money would stay for the benefit of my family. I don't want it to go because somebody made bad financial decisions. That's called a credit shelter provision, where the trustee will withhold those monies. Now, the last section is very sensitive. We're having a lot of stuff going on in the United States with opioids, with addiction. You're seeing this, and that is my trustee can withhold the distributions to somebody if they reasonably believe they're under the influence of drugs or alcohol. And this is just basically a go get a drug test. I'm not going to give somebody who's in the throes of addiction a bunch of money. I've seen this. I've actually seen this. We had one client in particular in Washington State argument with the individual. They wanted to give an outright distribution of the son who had had drugs and alcohol problems his whole life. And one of our attorneys was like, we would strongly recommend that you put in even an enhanced clause to give your trustee, like to actually require the blood test, the drug test. And unfortunately, mom passed a week later, son overdosed. And the money was it was like within 2 weeks. They had access to the funds, and they literally within days managed to just go on a bender, and unfortunately was not a good situation. So this is where you put in provisions that gives your trustee the ability to use reasonable sense to say, hey, for this particular individual, let's make sure that they are in a program, or we can do drug tests, or at least we're not just dumping it on them, but we could withhold it if they have drugs or alcohol issues. Or better yet, this is why I love legacy trusts. You're just giving the money out incrementally over a period of time, so you don't just dump it onto somebody. So I'm just going to call this unusual provisions only with a living trust. Can't do that with a will. Will is who gets it, right? So sometimes you have a will pointed to a trust, like Michael Jackson's case, right? Where they'll say, hey, we'll create a trust. But then I say, like, why are you doing that? Why are you forcing it into probate? I usually know because the attorneys make a lot of money. But you're like, hey, let's not do that. Let's stay away from court. Let's keep our stuff private so that it's not sitting out there in a public record. And let's keep it within the family. And we'll just keep our affairs to ourselves. So that's number 5, unusual provisions. Number 6, I just mentioned it, which is privacy. And I'm just going to write that straight on up. Wills are public. Oops. I can go pull up somebody's case that's going through a will, that's going through probate, and I can see their schedule of assets. I can see what things they have in their estate, who their beneficiaries are. I can see it. That's why we know all these things about Prince. That's why we know all these things about Aretha Franklin. That's why we don't know anything about Frank Sinatra, because a living trust, which he used, is completely private. So if you want privacy, you need to use a living trust. So private equals a living trust. Wills are public. You can go look it up. There was a case when I was up in Washington State. There was people targeting the decedent's homes. So if they saw in a probate that a decedent had children that were out of state, or that there was a question about beneficiaries and they had an inventory, they could actually go shopping. They could go right in the house, like, okay, these items are in here. And if they didn't secure them, they would break in and go take it. And there was actually a little bit of a ring of robberies, and they figured out, oh my gosh, here's what these all had in common. So a little bit, and again, another thing is, think about this for a quick second. Do you want your family's affairs and all your assets and everything put out there into a public document that anybody could search? All right, now number 7 is going to be weird. We're going to use a will 100% of the time. And the reason is this: if we set up a living trust and it's fully funded, we don't need to have a pour-over will. We don't need any will of any kind. But if I set up a living trust and there is an asset in your name, you still need to get that asset from your name, because you passed away, into the living trust. And you're going to need a court order. You're going to still need to probate it if you don't fund your living trust. Most people are pretty good about transferring their house, making sure that their checking accounts and things like that are in the name of the trust, so it's not an issue. But if you do have assets, like let's say I have a piece of real estate or something, you're still going to have a pour-over will, but we only have one beneficiary, where it's going to make it so much simpler, and it's going to be a smaller estate. So I could have a estate that's a $5 million estate, and I still may have to do a low asset probate because there's an asset or two. Maybe it's a car, maybe it's some checking account someplace, or something along those lines. And just keep in mind, things like your retirement accounts, you could actually name other beneficiaries. Insurance is going to go off of who the beneficiaries are. Insurance, unless you make your living trust your beneficiary. Like, there's certain things that, hey, even if I forget, I still get a little bit of forgiveness. But if I have larger assets, like a piece of real estate, I'm going to have to go in there and transfer that asset. But it's so much easier when there's only one beneficiary, and that's the living trust. So when I do a living trust, I always do a pour-over will 100% of the time. And I make sure that pour-over will is designating the living trust as the sole beneficiary of the estate. And I always put in the living trust that if you contest this thing, if you're a beneficiary and you contest it, you're disinherited. You're done. That way we don't get contests. We just want to make sure this thing goes smooth and easy, and we don't have a whole bunch of people trying to create nonsense in a court. And that's how you do it, by the way, is you say you're disinherited if you do it. So all we're doing is, we're always going to end up having a will, but we're minimizing all the downsides of the will, right? We don't want the contest. We don't want the long-term process. It might be that, hey, I can't get away from it. It's going to take 180 days, or it's going to take 90 days. Can't get away from that, but it's going to be a minority. It's going to be a small portion of the estate, and it's going to be one beneficiary. We're not going to have the nonsense. So that one always throws people off. So that's like, when we're looking at the big differences between a will and a living trust, there's so many reasons where people say, just do the living trust. And I'm always going to say, you're actually doing both. The living trust is way more effective. Like, always do a living trust, yes, but also always do a will. It's yes. Should I have a living trust or a will? I'm always going to, it's going to both. You're always going to have both. We just want it to be a pour-over will, as opposed to a will that's distributing all your assets. We still want the trust to control it, but I want to make sure that we're minimizing all the downsides of using that will. And then number 8, and I'm just going to call this, we'll just call this ancillary. Ancillary documents, and what do I mean? I mean healthcare documents, for example. Who's going to advocate for you if you cannot advocate for yourself? So it might be an advanced medical directive. It might be a healthcare power of attorney, depending on your state. We want to have those documents. In a living trust, they're always included. In a will, they're not. A will is a very specific type of document. When you do a will, it's just when you die. But what about when I'm alive? What about things that happen when I'm alive? I care about making sure that my estate is handled appropriately while I'm alive, way more than when I'm passed away. I want to make sure I don't lose control of my assets, that somebody's advocating for me. And in the healthcare world, that means a healthcare power of attorney, things like a HIPAA release, so that somebody can actually converse with a doctor about my medical information when making a decision on my behalf. So I need to have that sort of thing. And then something called a living will. A lot of people think of a living will and it's end of life decision making. And having somebody who can actually converse with a doctor in a meaningful way and follow your wishes. Do I want extraordinary methods taken to preserve my life, or do I want to go if the downside of preserving my life is greater than the upside? I need to make sure that somebody can have that discussion with the doctor and make that decision on my behalf. That's just on the healthcare. Then there's the financial side. What about making sure that if I'm incapacitated, like I live this, my father had Alzheimer's for 6 years before he passed, you've got to have somebody designated to make financial decisions on his behalf. We actually had to sue an insurance company. It's almost impossible to do, and like if you don't have those documents, you're going in for a conservatorship in the state and you're in a whole other legal proceeding, which is very, very time consuming and difficult and expensive. So we make sure that we have these documents ahead of time. What if you have minor children? Who's going to care for those minor children if I'm incapacitated or if I pass away? Who's going to watch my kids? Make sure it's all designated and in writing. How about gifts? How about just making it so that I can free flow and write out things that I want to go to certain individuals? Hey, my fishing rods, I want it to go to my buddy that I go fishing with all the time. My golf clubs, I want to curse one of my friends with who sucks at golf, and I'm going to give him my great golf, that type of thing. I can do that very easily with an ancillary document attached to a trust. Very difficult when I'm messing with a will. And so I want to make sure that I have these types of ancillary documents included. And so there's health, there's financial, there's things like my kids, there's things like gifts, there's even things like burial instructions, making sure that those things are designated in those ancillary documents. Also things like organ donation. Like if you try to do your organ donation in a will, I'm sorry, it's way too late. It's not going to happen. If you want to try to bless people, like that's something that's important to you, it needs to be in your healthcare documents. I want to be an organ donor, things like that, so that you can immediately converse with the doctor and say, yes, this is something that Toby wanted, or this is something that so-and-so wanted. So that is always a big one, and that is not in a will. You see people that do wills, a lot of times they'll do these really inexpensive wills, and they say, oh, all you have to ask yourself is, why are they doing that? Why are they doing the 199 will? It's because they make it up on the probate fees when they're handling the estate when you pass. Because what happens when kids see the will and they go, oh, here's the firm that drafted it, I'm going to go there for the probate. They get paid later. They're literally just kind of, those are assets. How do I know this? Because my partner Clint, his grandfather, that was an attorney, and that was the assets of his firm was this whole file cabinet of the wills that they had created, because they had a steady flow of probates, and that was a marketable asset for the firm. We do not want that. We do not want there to be probate expenses, so you're handling it up front at a much lesser cost. So let's just say that we use the Estate Planning Attorneys Association. They use a 3 to 7%. Just look at your estate and multiply it by 3 or 7%, and then say, would it be worth it to not have to do that? Even if I did it now, is it worth it to prevent anarchy in my family, or prevent and make it so that my heirs don't have to go through that process? Is it worth it if I set up a living trust now with all the ancillary documents? And I've yet to encounter a situation where the answer was it wasn't worth it. And another simple one you do is when somebody like a lawyer, somebody who's, you're sitting down talking to them, and they go, yeah, living trusts are for the rich, and it's really not that big of a deal to do a probate. Then you say, great, what's the cost of the living trust? Write it down and say, will you sign off that your firm won't charge more than this to probate my estate? So if the cost of the living trust is $5,000, right? Will you sign off that you won't charge my estate more than $5,000 to probate it? Oh, no. They'll say, oh, no, we can't do that. Well, why not? You just said it was cheaper, right? Like, you just said that it's not a big deal. So certainly you'd be willing to do that. They'll never do that. They don't do that. The reason they don't do that is because we don't know. What we can do is set up a situation where we can avoid it. So we don't know. I don't know, you don't know, nobody knows. Nobody knows until you're in it. You don't know whether whether by probating, I've seen litigation over Christmas plates. Just one side's attorney's fees in that case, because I know the attorney, was over $5,000 over Christmas plates. We don't know if that's going to be the situation because you put it all into court. You put it into the probate process. What we want to do is avoid that, all that issue, and hopefully nothing bad would have happened, but now we're just making sure that we don't ever have to find out. So we do the living trust as a reason so that we can avoid that unknown, and we now know exactly what it is, and we make sure that we fund it appropriately. We make sure that we're covering all these issues. Those are the big essential issues, and then you can have something called peace of mind in knowing that, hey, I've already wrapped this up, I made it easy, put a bow on it, my heirs aren't going to be sitting here fighting with each other, my heirs aren't going to be going to court all the time, they're not, we're going to minimize any expense associated around the transfer of the estate. We're going to handle it appropriately ahead of time. Hopefully you're creating a family legacy. Hopefully that seed gets planted and you start realizing that there's a lot of other options, that you can actually pass your values on to future generations. And by the way, if you ever, I always ask this to clients, like, hey, what was your great-grandparents' names? And invariably, the people that really know the great-grandparents are the ones that actually have a family value being passed down. Quite often it's because the great-grandparents created something that they're still getting a benefit from. And I don't mean that to be like narcissistic or crazy, but if you leave something to somebody, they'll remember your name. If you do not leave something to somebody, they probably won't. And so you're creating a legacy where it's like, hey, I'm creating, here's my values, here's me at this particular time. And if you want your family and you want your descendants to know about your values and things, create something that passes it down. All right, so I just went over 8, see if I can do this right, 8 major differences between a will and a living trust. Hopefully some of these things resonated with you. If you have any questions, by all means reach out. If you think that there's people that could benefit from this information, share it. And as always, I have a free YouTube channel. Subscribe and click that notification bell because it'll let you know when new videos come out. And hopefully you benefited from this information.